everyone, and welcome back. You're watching The Money Show on ET. Now, we've just been talking about those individuals who unfortunately lost their job as their companies undergo financial stress due to the COVID pandemic, the lockdown, and the economic crisis that has engulfed the country and the world. But if you, let's say, are laid off, or if you find your job no longer available, what exactly are you entitled to receive, if anything? So to talk about that and to talk about the nitty-gritties of, everything to do with, compensation that you are owed, let's bring on board now Pooja Ramchandani. She's a partner with Shardul Amarchand Mangaldas. Pooja, many thanks for joining us today on ET Now. So to start with, this one thing that we've been noticing is that a lot of employers are forcing their employees to take long periods of unpaid leave, or what we call as suspending employment. They call it temporary. Firstly, can employers do that, Pooja?
So see, under Indian law, an employer does not have the right to furlough or send employees on unpaid leave or suspension without any reason as such. Like you can do in other jurisdictions. The furlough is an option available for employers in other jurisdictions. But a leave without pay is not possible under Indian laws unless and until it's in a case where an employee has exhausted his or her statutory leave entitlement and requires additional leave. In such cases, an employee makes a request to the employer, and in that case, employer has a discretion to grant additional leave, which can be on without pay basis.
Pooja, we say layoff, we say suspension. If you could just talk to us about the difference between the two.
So layoff in general parlance, Mobina, is used interchangeably with the word termination. But when you look at it from industrial law perspective, layoff is a defined term under the Industrial Disputes Act, and it means failure or inability of an employer to give employment to the workmen on the employer's rolls. And this failure inability has to be related to prescribed reasons such as shortage of raw material, breakdown of machinery, natural calamity, which COVID is, amongst other prescribed requirements. So in case of a layoff, it does not mean that there's a termination of employment. It is in the nature of a suspension of employment and not a suspension in the way we otherwise understand it. And I'll come to that in a bit. So, and it's usually for a short duration. And during such period, the workmen who have been laid off, especially those working in factories, mines, and plantations, are entitled to receive a compensation which is equal to 50% of their basic wages and DA. Now, when we come to a suspension, suspension ordinarily is used in the context of suspending an employee and is typically in relation to disciplinary proceedings and is not a termination of employment or a suspension of employment as understood within the meaning of the Industrial Disputes Act in relation to a layoff, as I just explained further earlier. So when there's a disciplinary proceeding initiated against an employee can be suspended during this period, and it's usually done so that there's no tampering of any evidence or the proceedings. And during this period also, the law does prescribe, the period of suspension and whether you pay wages during such period or not for the worker category, where it says that the worker category must be paid at least 50% of wages for the first 90 days and thereafter 75% after 90 days if the proceedings or the investigation goes on beyond that. Now, when we look at white collar or non-workman category employees, the law doesn't really prescribe for similar requirements, and suspension for disciplinary proceedings is governed by company policies. Usually we see company policies being silent on this, or even if there is a point on suspension, they don't really say much about with pay, without pay. And typically, as we've seen, suspension for white collar employees is on a payment basis, payment of wages basis.
Pooja, are employers required to give notice to employees in case they are either being, suspended or, like you said, laid off or permanently terminated?
Yes, you have to give a prior notice, especially in the case of termination. Labor law does prescribe for a period of 30 days. to be given for termination of employment. However, when you look at termination of employment for reasons of misconduct, then in that case, this 30-day notice is not required to be given, and a employee can be dismissed summarily. So summary dismissal essentially means that you don't have to give the 30-day notice, but this has to be preceded by a domestic inquiry, and this domestic inquiry has to be in accordance with the principles of natural justice, where the employee has to be provided an opportunity to be heard and defend his or her position.
So what can and what will an employer have to pay his or her employee in case if they are terminating their employment? What will be the compensation or package that they will have to pay the employee?
So by layoff here, I'm assuming you mean termination from employment?
Termination, yes. Sorry, yeah.
Yeah. So, see, where you're looking at a termination of employment. Now, Indian labor law divides workmen broadly, employees broadly into two categories: workmen and non-workmen. The workmen category employees are protected under the Industrial Disputes Act in relation to a termination, which is for reasons other than on account of a disciplinary action. And the Industrial Disputes Act prescribes that all workmen category employees who are, laid off or their employment is terminated for business reasons, etc., and who've completed 1 year of continuous service are entitled to be paid what is called a retrenchment compensation or a severance. But this protection is not available for non-workmen employees under the Industrial Disputes Act. And just to explain for the viewer, the non-workmen employee is typically the white-collar employees and should be understood to mean those in managerial capacity or supervisory capacity, and in case of supervisory capacity, drawing wages in excess of 10,000 rupees per month.
Is there anything if you're suspending employment?
Yes. So let's say there is a layoff. So the law does prescribe again for the workmen category who are in factories, mines, and plantations to pay this, compensation during the period of layoff, and then also says that if this layoff continues beyond a period of 45 days, the employer has a right to retrench the workman. Now, when you look at retrenchment or termination of employment for, reasons as, the COVID situation, etc., where we've seen so many employees losing their jobs and employers being constrained to take such action because of cost-cutting measures and mounting losses, etc. Nonetheless, under law and contract, the employer is still obligated to pay the dues owed to an employee at the end of their employment. Now, these dues or these payments or separation payments are comprised of statutory payments and contractual payments. So what would the statutory payments be? The statutory payments comprise of the salary till the last working day, leave encashment, which is encashment of the unutilized privilege leave, statutory bonus under the Payment of Bonus Act, which is to be paid on a pro rata basis to those employees who are eligible. Eligible employees would mean employees earning less than 21,000 rupees per month. Gratuity is another component which forms part of the separation package, which is to be paid to employees who have completed 4 years and 240 days of continuous service. And then there are the contractual dues, which would comprise of, incentives or superannuation benefits, etc., depending on company policies and the contract. Provident fund is usually contributed to a statutory fund maintained by the Provident Fund authorities on a monthly basis. And any transfer or withdrawal of this accumulation would need to be dealt with the PF authorities as prescribed under the EPF Act. If Provident Fund is maintained as a private fund and there will be a trustee and rules and a fund maintained by an employer, then one will have to look into the rules there, and usually the payout or the transfer happens as per the process under the rules prescribed under the trust deed and rules relating to the Provident Fund.
All right. Okay. So perhaps if a white-collar employee is terminated, he or she may not be entitled to any severance package as such. But yeah, those employees in workmen category who finished 1 year of service, they would be entitled to a severance package. All right, Pooja, it was lovely having you with us today on ET Now. Thanks so much for joining in, and we'll surely be discussing the labor codes as well with you very soon once, the bill's out there and you've read through, of course, that really heavy act. But yeah, that's all for now. And we'll do one thing. We'll take a very short break on the show. Don't go anywhere.